Good afternoon. Welcome to another edition of Legal Access. We get together each and every Thursday at this time to answer questions about different aspects of the law. Today we're going to be talking about wills, trust, and estates. It's a topic that a lot of people have a lot of questions about. I will tell you it's probably our #2 most questioned show that we have. So if you have any questions about wills, trust, or estates, make sure and get those calls in as soon as possible. Don't wait till the end of the show because we might not be able to fit you in. Phone numbers on your screen there, 843-848-8080. Here on the panel to answer those questions today about wills, trust, and estates from the McGuire Law Firm. First of all, Brittany Jones.
Hey Dave, how are
Also
you?
from the McGuire Law Firm, we got Mike Smith.
Hey, Dave.
And at the end of the panel there, not from the McGuire Law Firm, Brett Davis. Hey, Brett.
Brett, good to see you.
We're super excited to have Brett with us today. And Brett, your practice obviously focuses on wills, trusts, and estates, among some other things. What else do you guys practice?
Mainly estate planning, elder law, probate, tax planning. I'm also a CPA and so do a lot of tax planning as well.
That's great. And your office is here in Myrtle Beach as well?
Yes.
Awesome. We're super glad to have you with us today, Brett. Obviously, he's going to be very well equipped to be able to help us answer some questions.
Not for nothing, but Brett did my will as well. So, you know, that's not getting a discount by
Plug.
saying that here on the air, but I'm just saying that that's so. So anyway, he's got the expertise. If you want to give us a call, again, the phone number is on your screen, 843-848-8080. And Brett, I'm sure one of the questions you get a lot of at your practice is, you know, before I moved here from Pennsylvania, I had a will just done. Do I have to get a new one just because I moved to South Carolina?
Not necessarily. We'll accept wills from out of state. You know, that is a question that comes up a lot, Dave. And if it was valid in the state where it was done, we'll accept it here. However, people come down and they'll oftentimes have changes in family or things they just didn't think that were necessary to revisit in their will. So it is important to sit down with somebody and talk through that and see if there's been some changes.
Now, when I did have my will done with you, my wife and I, my son was still alive. He's unfortunately passed in the past year and a half. Do I need to come in and have my will redone now that there's been some major changes in my family dynamic?
But I always enjoy meeting with you, Dave. So anytime you can come see me will be great. Yes, you need to come see me at any time. Not necessarily, to answer your question. If you've got things in the will that take care of it, you don't necessarily have to do that. However, it's good to sit down and talk through it and to see if that still works or if it still applies. In your case, it may be good to sit down and talk through that again. But you may not need to do anything, but it won't hurt to talk through that.
Wills, trust, and estates, that's our topic here today. The phone number's on your screen. I know you've got a question about it. Now, the other question I'm sure that you get quite a bit of, whether it's at cocktail parties or just in general at the office, is if I die without a will in the state of South Carolina, what happens to all my stuff?
That's a good question. So if you have a spouse, half goes to the spouse and half goes to the children. No spouse at all goes to the children. No children at all goes to the spouse. If you don't have a spouse or children, then it goes back up to your parents. If you don't have parents, then it goes down to your siblings. We've got a case now to where we don't have a wife or children or parents or siblings, that we're going back up to the grandparents and then down to the first cousins and first cousins once removed. And it's going to be interesting. We're working on that estate a little yesterday. So the state sort of writes a will for you if you don't have one in place, and they're going to get the assets somewhere.
And I know, you know, I bet that people are surprised by that. I would think, you know, that oftentimes people think, oh, well, if I don't have a will, probably just all goes to my spouse, right? But that, just like you said, Brett, that's actually not the case.
Where it becomes a sort of an issue, say you've got a spouse and young children, and say you've got a house that either is titled as tenants in common or a house that's just in the husband's name. Say it was just in the husband's name when they got married and still in just the husband's name, and then husband passes away. Well, then that house will be owned half by the spouse and half by those young children.
And that's not ideal.
That's not ideal at all.
For a lot of reasons.
Sometimes that happens.
Right.
You know,
right.
so it's good to resolve those issues.
If one of the children were to pass, like Dave was saying, and they have children, how is that division done?
Yeah, it just keeps going down the line of the issue, the descendants, the blood or adopted descendants, just keeps going down the line.
Gotcha.
So they would get, say for instance, like Mike was talking about, if the same scenario, half goes to the spouse, half goes to the two children. If one of the children was deceased and had children, their 25% would go down to their children.
Right.
a lot of unique family scenarios, I think,
Absolutely.
these days, and definitely, like you said, better off to call, talk with an attorney and get it checked out and see if it's would pass the way that you would want it to anyway, or you might,
Right.
probably better off with a will. For a lot of reasons too, right? Not just for who's getting what, but there are a lot of other benefits as well to having a will.
There are, and when you say will, I think you're collectively saying have an estate plan.
Sure,
That
yeah.
may involve a revocable trust or an irrevocable trust, but it's important to have a plan in place because actually I tell clients this, it sounds cute, but it's true. No plan is a plan,
Yeah.
and that plan may not be what you want to have. So.
When you talk about the wills and stuff, what about powers of attorney? What are those and when can they be used, and are they something that you would recommend?
Absolutely. Powers of attorney give someone the right to sign on your behalf for financial purposes. That's kind of the traditional power of attorney. You can have a limited power of attorney where it limits what you can do, like in a real estate transaction. Also, we have healthcare powers of attorney, which say give someone the right to make healthcare decisions for you. It has some HIPAA authorizations in
Right.
there as well. And it's a place where they can take you off of life support or agree to organ donation
Right.
on your behalf.
There are a lot of good reasons for having those too, not just for married couples, but, Mike, I know you've got a son in college, it might be a good idea to have one for him, in case you needed to access or help him do different things. Do you see that come up very often, Brett?
That's a good point. It should come up more often. Rarely I have had that.
Okay.
But it should come up more often. If you've got a child in school or something and you want to be able, once they're legal of 18 years of age or older, they can sign a power of attorney, and it's important to do that. Where it comes up a lot is where I've got a disabled person and the parent is the guardian of the disabled person. If they've got a certain level of capacity, that disabled person can sign a power of attorney. If not, then we would need to go and get a conservatorship or guardianship once that person reaches age of majority.
Right.
So that's a good point, because once the child reaches age of majority, then they're making those decisions on their own. And if they're like me when I was in college,
All of us probably.
What about a situation where children of an elderly parent are starting to notice that the parent is not as cognitively there as they were before? Can you still get a power of attorney under those circumstances?
that is also another very good question. Say you've got somebody, a parent who is losing some capacity, but still knows sort of who they are
Yeah.
and who the family is and what they want to have happen. Do they have enough capacity to sign a power of attorney, or do you have, if not, then you have to get a conservatorship done and get a conservator appointed for them for the money and a guardian for their person. Normally, they'll have capacity to sign estate documents even though they're losing capacity. It's a fine line where they lose the ability to sign those documents. There's a little more capacity needed for a power of attorney than for a will or a revocable trust. But it's a moving target, Mike, and we wrestle with it from an estate planning standpoint of when do we go over that line.
If you've got a borderline parent, is it better to have the family doctor of that parent involved in that process?
You can, but the attorney's the one that has to do the test, and they don't have to have capacity, full capacity, continuously. They need to have capacity to understand what's going on when they sign that document.
Right.
And the attorneys there doing that test, we don't really call it a test, but we do a test, when we're sitting there signing these documents. Do they have capacity to sign these documents? You also want to look at the collateral issues. Is there strife in the family? Are people arguing, or are all the family members on board of what's going on and they understand what's happening? And is the person signing the documents attempting to do something that's in contravention to a normal type of an estate plan? Are they giving everything to the guy that's done their yard, or they're putting the next door neighbor's daughter as their agent under a power of attorney? So you need to look at the whole picture when you're evaluating the capacity.
Yeah.
Tell you what, we need to run to a break here real quick. I told you at the beginning we'll have a lot of phone calls in this show, and we got a lot of people on hold right now. If you're on hold, hang on. We'll get to you in just a second. Got to run to a break. We'll be right back with Wills, Trust, and Estates. Get your phone calls in as soon as possible. It's Legal Access, brought to you by the McGuire Law Firm. All right. Welcome back. It's Legal Access brought to you by the McGuire Law Firm. Today we're talking about wills, trust, and estates. If you have any questions, the phone number is right there on your screen. Give us a call. We'll get you on the air and get those questions answered. Here on the panel to answer your questions today, we have Brittany Jones and Mike Smith, both from the McGuire Law Firm, and Brett Davis is with us here today as well. So let's go to the phones right now. We've got a lot of people holding patiently through that break, and we appreciate you still being there. Let's go first to Donald from North Myrtle Beach. Donald, thanks for hanging on. What's your question today? Go ahead, Donald, you're on the air.
Yeah, my question is, I had a friend pass away, he didn't have no will, no nut, and the closest relative they could find was a niece in Virginia. And apparently the niece in Virginia get his neighbor down here, the authority to handle the estate or something. And it ain't been 90 days, and they got a fire sale going over there. Is that legal?
Good question. So it sounds like there's an estate, or somebody here passed away, and their closest relative was a niece, did he say?
Yeah, in Virginia.
In Virginia, and that niece has given a neighbor here locally the authority, one way or another, to act as the executor of the estate.
Yeah,
is what
or
it
to
sounds
sell
like.
everything, yeah.
Well,
They
with,
have to have a personal representative appointed and things of that nature before any of that happened.
They should.
yes, I think yes, because you wouldn't be able to sell the real estate without someone with authority to do that. He must be talking about the personal property, the cars, furniture,
That sounds like.
clothing, jewelry, that kind of stuff. That's really not supposed to happen, before a personal representative is appointed. So I think that's what he's referring to. So if somebody has an interest, but then the question is
Yeah.
who's going to get those assets? The person that can really complain about it is the one that's going to get the assets. If they're the one giving somebody authority, then I don't know, what the problem would be if they're the one getting the assets
Right.
anyway.
Right.
And if the person died in South Carolina, would the estate need to be opened in South Carolina?
Not if they died a resident of South Carolina.
Right.
They could die here and be a resident somewhere else. If they died a resident of this state, yes, you need to open an estate administration here.
And
If-
you could check the public records to see if there's an appointment of a personal representative.
The probate court, probate court records.
Yeah, that's something that you can look up
Yeah.
online, who's been appointed as the personal representative of an estate, or call up the probate court. And also, I guess if the niece was appointed, or the rightful person to serve as the PR, she could potentially, renounce her right to do that and ask that this other person be appointed.
Yeah.
You wonder, though, he says
Possibility.
niece, is that the only heir of the estate? When you
Well,
have an estate with
yeah.
no will, the people are called heirs. If you have a will, they're normally called beneficiaries. So when we refer to heirs, we're saying people who's going to take if there's not a will. I wonder if the niece really is the only heir, or if there's some other
Yeah.
people out there who are legitimate heirs of this
Sure.
estate.
Yeah.
Donald, a very complicated question. Hopefully we gave you some answers on that, and I don't know who you'd contact, maybe the probate court, to find out what your next move might be. If you, not being related to your neighbor who this happened to, I don't have any kind of say-so over that property, but if you're you want to make sure that nothing is done incorrectly, then that might be your next move. Donald, thanks for calling. Let's go to Sherry right now in Myrtle Beach. Hi, Sherry. Thanks for hanging on. What's your question for us today?
Hi, thank you. My question is, I did a will with my husband, and since that time, we have recently divorced. And my question is, if I died today without a new will, would the things still go to my now ex-husband, or would it go to my children? Thank you.
It's a good question, Sherry. And Brett, what do you say on that? I'm sure that's
The answer is no. We have a statute that says that it voids devises to a spouse if there's a divorce.
right.
But that needs to be looked at. They need to clean that up.
Yeah.
But
Absolutely.
there is a protective statute that deals directly with that.
So from the second you are officially divorced, that is null and void as far as the will is concerned.
But that doesn't necessarily, we still don't know exactly where it's going to go. We need to look at the rest of the
Right.
terms of the will.
Exactly. So it's not going to go to your ex, but you need to make sure where it is going to be going to, Sherry. Thanks for calling. Appreciate it. Let's go to Merle's Inlet right now. Jeff is on the line with us. Hi, Jeff. Thanks for hanging on. What's your question for the panel today?
Thank you very much. My mother passed away a while back and left me and my sister at that time heirs, of course, of the will, split exactly half and half, no problem. She passes away in January 23rd. Left a niece, my niece, her daughter. They wouldn't allow me to have access to the 2009 will, which superseded the 2006 will, which left Gail, my sister, who passed, everything. So I had to take them to court. The judge at that time allowed the lawyer that wrote both of the wills. When she changed it, we went back to, right there, there's the woman that wrote the 2006, the lawyer. They lawyered up. They pled the fifth. So I couldn't even get my will to prove that, or find out why the lawyer didn't put it in probate. I lost like $300,000 due to that. So I'm just wondering if what I can do to the lawyer. I guess I should sue the insurance company that insured the lawyer out. Is my best guess from what people have told me so far. Thank you for listening. I went on a little long. Apologize.
Oh, no, it's okay. Thanks, Jeff.
So that's a terrible question. but let me address it.
Situation, huh? Yeah.
Yeah, that's a terrible situation. So this is something that most attorneys won't tell you, but there is a case involving a local attorney here years ago that does give some rights to certain beneficiaries. So there is something that can be looked at there. And so what can you do with the attorney? Not to get great details, because I don't know all the details, to be honest with you, but there are grievances that can be filed, but we don't know what the facts are involved here. A person representative is required by statute to file a will within 30 days of somebody passing away. A later will, if it does supersede the previous will, would be the controlling document. Mm-hmm. There should be no reason why somebody would withhold that. You also have a question of who had the original document. If you don't have the original, then there's a presumption that maybe the original was destroyed. So if you just got a copy, there's no real obligation that you have to go and file a copy, not knowing whether that is still the original last will and testament or not. So what he's mentioned there has several tentacles to it. You really need to do some fact finding and see,
Right.
Where was it? Was there an original will? And then also you can do a later will that maybe only revokes a portion of a previous will.
Right.
So we really need to have all the facts lined up, and then we can give them an accurate assessment of did the attorney that was involved do something wrong? Was this following case law or following statutes? Do the beneficiaries have some kind of a cause of action as a beneficiary against the drafting attorney, which actually there was no privity, there was no relationship between the beneficiary and the drafting attorney, but we have a case that sort of goes into some scary area about who has grounds to bring some kind of an action. But that really has to be flushed out. There's no way to get all the facts with just what he
Right.
told us there.
Well, who's the general keeper of the wills? I mean, if I put a will in right now in 2006 and then 2009 I put another will in, and one of my beneficiaries is not aware that I changed it or did something else, how are they going to know that I did two different wills?
Well, that's a great question. See, did you want to take it?
And I was just saying, you are the keeper of your will, right?
Well, yes, sort of yes, maybe kind of.
Ought to be.
Some law firms will want to retain the original documents in sort of like a safe that they keep in their office. I don't like doing that personally. I give the original to the client and say,
Yeah.
you need to keep this document. But on occasion, some law firms that I'm familiar with have, in practice, just kept the original documents. I don't recommend that, because then you're responsible.
Right.
Then if they ever revoke it or do a new one, then you still got these old ones in your thing, and then people have to come. So it's just better, in my opinion, not to
Yes.
do that.
Yes.
But you have to find the original will.
Yeah.
That's very important.
So one thing, and I know once upon a time, some years ago, I did some estate planning and probate work myself, and that was the same thing. We would tell clients, you keep your documents, your originals. We're not going to keep them here at our office.
Right.
You take them, you should put them in a safety deposit box, a fireproof safe, something like that. And then, had a little sheet, a little form for them, or advise them. You should let your loved ones know that you do have a will and where it is located, and how to access it. And if you do update it, then you go put your new updated one in that same safe place. That way your loved ones do know where to find that original document when the time comes. Because as Brett said, you do have to have that original to submit to probate. Otherwise, there's the assumption that it may have been destroyed. So.
And you can probate a copy, but it becomes a formal proceeding where you have to have a hearing and you have to prove that this is the actual will.
Right.
That the original has not been lost, stolen, or torn up or revoked in some way. But that's a lot more difficult than probating the original document.
We got to run to another break here real quick. As soon as we get back, we got a couple more people on hold. We'll talk to them and get their questions. But if you have any last minute questions on wills, trust, and estates, still got about 10 minutes to get those questions in. So call us on the number on your screen and we'll get you on the air here. It's Legal Access, brought to you by the McGuire Law Firm. It's Legal Access from the McGuire Law Firm. Today we're talking about wills, trust, and estates. Got a little under 10 minutes left here, so if you'd like to get a last minute call in, go ahead and give us a call. The number's on your screen. On the panel here to answer your questions, got Brittany Jones, Mike Smith from the McGuire Law Firm, and also Brett Davis here as well. Now we do have a couple of people on hold already. Let's get to Lisa first of all in Myrtle Beach. Hi Lisa, thanks for hanging on through the break. What's your question today?
Yes, sir. My father passed away a few years ago, and come to find out, when his brother passed away here recently, his wife found that he had a couple life insurance policies for me and my brother. My father did, and I guess my uncle got a hold of them and kept them. We're waiting to hear from the insurance companies, I guess. Is there anything else I need to know about this?
So insurance policies are most often things that pass outside of the probate process. So they're considered non-probate assets because they typically have a beneficiary named, and even contingent beneficiaries oftentimes. So usually those are things that are handled directly with the insurance company. You don't have to have a personal representative or an executor handle those things. They would just pass outside of the probate process. I don't know that if someone was not the named beneficiary, that they would be able to get access to those things.
Right. So Lisa, if you think that you're being getting the short end of the stick on this, make sure and contact somebody to make sure that everything is righted. But thanks for giving us a call. Let's go to Betty now in Surfside Beach. Betty, thanks for calling in. What's your question today? All right, Betty, we're having trouble hearing you right now. Are you still there?
Yeah.
Okay, go ahead. We can hear you now.
Yeah. And I'm wondering, and I have a benefit in my state. I'm wondering,
Okay, Betty, we're having trouble hearing you right there. You might want to, number one, turn your television down, and you might want to give us a call back. We might be able to fit you in before the end of the show. We had a couple of people that didn't want to hang on hold here, so what if they have a will that's already made and they want to take somebody out of the will? What's the quickest way to do that?
They can do a new will or do a codicil to that will. Also, a question that comes up related to that is, do you have to specifically state in your will if you want to disinherit a child? For various reasons, occasionally people will need to disinherit a child for whatever reason may come up. In South Carolina, you do not have to specifically name them or give them $1 or give them $10. That's a question that I get frequently. They just, if you don't leave them anything, then they don't receive something from your estate. However, if you don't do a will, they may be entitled to something as an intestate heir, or if you do a will prior to them being born, they could have an interest.
All right, I only got about a minute left. I know another question that's frequent is if somebody wants to make sure that one of their heirs get their house, is it a good idea to put their name on the deed to try to avoid the probate process?
That does come up a lot also. It's called a poor man's will. Yeah, we don't recommend that for tax purposes. You get a step up in basis whenever someone passes under Section 1014. If you give something to somebody during life, they get the same tax basis that you previously had, called a carryover basis. So if you give somebody something during life, you may avoid the probate process, but you may give them a much lower tax basis. If they sell it after you die, they're going to have a lot of gain they wouldn't otherwise have to recognize and pay tax on.
We appreciate all the calls today and appreciate you watching. Next week when we get back together, we're going to be talking about HOA law. And if you thought today was busy as far as phone calls are concerned, just tune in next Thursday and you'll see what busy is all about. I want to thank Brittany Jones, Mike Smith, and also Brett Davis for being with us here on the panel today. My name is Dave Priest. Again, next Thursday, HOA is our topic. We'll see you here on Legal Access, brought to you by the McGuire Law Firm.
Lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal advice.